we've talked some today already about what clinical legal education is and about many of our accomplishments as well as those over the first 50 years at the Mandel Legal Aid Clinic. So this panel is about what about the next 50 years? The future. What does the future of clinical legal education look like here and elsewhere? What are our hopes? What are our predictions? And how do we think clinical legal education will fit within the broader legal curriculum? I'm honored. So I'm Craig Futterman, as Herschella said. I'm a clinical professor here at U of C and direct a civil rights clinic. And I'm really honored to try to facilitate a conversation today led by another outstanding panel about the future of clinical legal education. Just one obvious kind of observation before we start, which is this is an all-boy panel. And it's particularly worth noting that in the context in the two folks who really organized this, put all the brain power into this, are Herschella Conyers and Michelle Geller, and that's who we should really be showing deep appreciation for this entire symposium. They're fantastic. So, without any long introductions, in this batting order, we're going to start with Steve Wisner, trailblazer, clinical legal education, professor at Yale. Been there probably 40 years or so.
37.
Almost 40. 37. And, you know, an innovator who helped us understand that legal education is a lot more than simply teaching students how to think like a lawyer, and undoubtedly will be a leading voice in shaping the future. Marc Kadish, although we're not sitting in this order, Marc Kadish is going to be second up. And Marc Kadish is the director of pro bono and legal training at the law firm of Mayer Brown. I always forget, is it Rowan Marr now?
No, just Mayer Brown.
Just Mayer Brown now?
Right.
Rowan Marr gone.
They'll probably run the firm in 5 years, but the name is gone.
And Marc was a clinical professor at Chicago Kent for nearly 20 years. One short thing I almost tried, I was being considered to take his job after he left, and then when I met with everyone there and folks were just like, Marc is irreplaceable, I said, I'm leaving. I left the state and went to California after seeing what Marc was done. So someone is sorely missed, though, in clinical legal education today. And finally, Michael Pinard, professor of law at Maryland, who directs a prisoner reentry clinic, one of the nation's first and only prisoner reentry clinics, and recently received an award, a Shannara Gilbert Award for Emerging Clinician. And in many ways, I mean, Michael is a true star now and represents, you know, I think as much as anyone here on the panel will help to shape what the future of clinical legal education is. So I'm going to give folks about 10 minutes each, and then I'm going to try to facilitate a broader conversation with everyone.
This doesn't feel very clinical with us sitting up here and you sitting out there, so we're hoping that we can imagine that we're a circle sitting around and talking to each other. I'm afraid I'm the past of clinical legal education, not the future. My future is behind me. Michael is the real future of clinical education. I hope you'll indulge me for a moment to reminisce about what it was like here at the University of Chicago Law School in 1960 when I arrived as a first-year student. We were told this morning by Randy Pickard that I teach at a law school where no law is taught. So I guess the first question I hope we can get to is what does it mean to teach law? And I think that's an important question. And what does it consist of? This panel is entitled, The First 50 Years Are the Hardest. And my second question is, this is the 50th anniversary of what? What is it that we started? Where did we come from? And where are we headed? My walk down the corridor of this law school today has been a little spooky for me. All of my former professors, who are all dead, are up there on the wall. And I imagine a picture of me when I'm dead hanging someplace as a little spooky. But just for a moment, I want to go back to 1960 and ask myself, what did we as students learn here And how is it different? Well, of course, we learned doctrine and theory and the analysis of appellate court opinions, and how to think like a lawyer, whatever that means, but we also learned about legal realism. We learned from Carl Llewellyn and from Soya Menchikoff and others the role that was played by lawyers and judges in making law relate to life and life relate to law. And that was, I think, the most important lesson I got out of being at the University of Chicago in those days. Everybody says legal realism is dead now. I don't believe it. And then there was Henry Kaganiak. Henry was a crusty curmudgeon down in the dark basement, and if you wanted to, you could volunteer to help him and another young staff attorney, whose name I've forgotten, representing individual clients. And Henry was never in a good mood, and we had very little responsibility. We were given assignments and told to do them, and then the results were always subject to scathing criticism. But it was a good introduction to what we later came to refer to as experiential learning. I'm not sure it was the experience of getting along with Henry or the experience of actually working with poor clients on cases. But it never occurred to me that that was a clinic. I thought it was just a way to keep our sanity. We could go down there and spend some time doing real law with real clients, and hope that we weren't abused too much. So the 50th anniversary of what is a question that interests me a lot. The Mandel Legal Aid Clinic back then handled individualized service cases with law student volunteers, no clinical faculty, no credit for the work. The Mandel Clinic now is amazing. When I see that building, I just can't believe that I still don't have to walk down the stairs from the outside into that dark basement. The other title of our panel is Out of the Shadows. I think it's Out of the Basement. Part of the law school curriculum, clinics are now. There's a clinical faculty and a very excellent an amazing clinical faculty. Students get academic credit, and there's a wide variety of clinical offerings, ranging from representation of individual clients to engaging in complex financial transactions and community lawyering work, taken on the Chicago Police Department like Craig does. It's really quite a clinic. So we thought that we would raise some questions for each other and for all of you as an effort to try to stimulate a conversation. So I guess my first question is, what's the education in clinical legal education? I think that's you. That's me? Yeah. I'm sorry. Off.
Sorry.
That's like...
I'll shut mine off now, too.
When that happened to Rudy Giuliani, that was the beginning of the end of his presidential run. Are we just teaching practice, or is there something more involved in what we're doing? Is there a political, a social, a moral component to the work that we do? Is there something that we're trying to instill in students beyond the skills of lawyering and the ethics of lawyering? Do we have an ambition to be socially relevant? There were some intimations this morning that not everything that happens in this building is really socially relevant. And sometimes when you listen to or read about some legal theory, it seems not really socially relevant. It seems to be theory without its feet on the ground. So is the clinic a place where socially relevant legal education takes place? And who should teach socially relevant stuff? Is it only the clinicians, or can Randy Picker also be socially relevant? A third question is, what's the argument for requiring clinical education? Is there one? The Carnegie Report clearly states that clinical education should be mandatory. I'm not convinced. I do think it should be available to any students who want to take it, and they should be encouraged to take it. As I think over the years about some of the students I've met in my law school, I wouldn't want them to get near any of my clients. But maybe I'm wrong about that. Maybe they too have a right to become humanized. How should clinical legal education fit into the law school curriculum? There was some dispute this morning about whether it should be mainstreamed in regular courses. I think I don't agree with that, but it's worth discussing. Should clinical legal education come early or late? Should it be a third-year transition from law school into practice, or should it happen as it does in our law school in the second semester of the first year, so that students spend their 3 years of law school moving back and forth between a very academic curriculum in which, as Randy Picker says, no law is taught, and a very clinical experience in which law and a lot of other things are taught. What evidence is there that student participation in law school clinics influences them when they leave law school in the way that they practice law or who they practice for? In that regard, Stephen Krieger's call for some empirical investigation seems to me very important. All of us would like to believe that we have a profound effect on our students, that we really humanize them, we make them understand the importance of lawyers in addressing significant social problems, but we have no evidence to prove that we actually succeed in doing that, and it would be nice to have that. Of course, if we thought we weren't doing that, we would all cut our wrists or something, but we do think we're doing that, but we don't have any proof of it. How much of what we do should be education, in quotation marks, and how much should be service to clients in the community? Is there a real tension between education and service to clients in the community? Or can we synthesize those two? Is what we're teaching about and how to provide service to clients in the community? Another theme that has come up is what's the relationship between the clinic and private bar? I know Marc Kadish is going to talk some about that. I'd just like to give a few examples of how I think the private bar can be a partner in clinical legal education. Marc will tell you about the Supreme Court Clinic at Yale, in which two partners in their Supreme Court practice group in Washington actually come up to Yale and work with a group of students and two faculty members to handle both cert petitions and merits briefs before the United States Supreme Court. We have a community development financial institutions clinic where we're developing a community development bank, which is a bank for poor people, because we've been seeing over the years more and more and more that our clients not having bank accounts spend exorbitant amounts getting their checks cashed, can't have no credit ratings because they don't have bank accounts. There is this federal statute that provides for community development banks. Covington and Burling has given us one of their partners who's an alum of the law school who flies up every week to work with us and the students in developing a bank. We developed recently a shopping center in New Haven in a poor neighborhood where people were shopping at little neighborhood grocery stores and paying a huge amount and didn't have a supermarket. And a major New Haven law firm, what passes for a major law firm in New Haven, I think they might be up to 100 lawyers already, which is huge for New Haven, gave us a corporate and a real estate partner to work with us and the students in representing a neighborhood corporation in developing a supermarket. So there are ways, and in all of these situations, the lawyers from these private firms coming in and working in the law school really loved it. They provided excellent supervision and teaching. They gave us access to their knowledge. They did it without any compensation at all. In fact, we've uniformly found that whenever we receive attorney's fees in cases in which the private bar has been involved, they donate them to the clinic. They don't keep them. And in our view, this is a much more effective way of involving the private bar in the work we do than in urging students to demand that they get pro bono work when they go to the firm. I would rather have those lawyers come and teach our students what they know how to do rather than insist that they take on cases that they don't know how to do for clients that they may not have the best ability to work with. Another development, I think, and we want to talk about this, is so-called no-client clinics. Our bank clinic is a no-client clinic. We're working with two community organizations, but we don't have any clients. We are just working together to develop this bank. But we have a client community out there of poor people who the bank will serve. We have an international human rights clinic that works with partner organizations, international human rights NGOs and the UN. No real clients, but working on projects and issuing reports and doing investigations. We have a legislative advocacy clinic that is sort of in-house with Connecticut Voices for Children, which is a children's defense fund in Connecticut. The clients are all the poor children in Connecticut, but no individual clients. And I think it's worth talking about whether that's really a clinic. Is it a clinic if the students don't have clients but are working on projects that benefit a client population? Have we changed? Obviously, we're much more sophisticated, entrepreneurial, opportunistic. We're doing all kinds of stuff that we didn't do at the beginning back in the dark ages. But I really think it's all new wine in an old bottle. And the old bottle is experiential learning with a social justice ambition. I have pages and pages of other stuff, but I think I'm going to stop. Go ahead.
I guess my first thing that I wanted to say is I was just starting in clinical education when I heard Steve speak at a number of conferences. I stole one of his lines and used it throughout my 20 years at Kent Law School. I told him that when we first said hello this afternoon. I remember him saying, I've been at Yale Law School 20 years now. Don't tell anyone they think I'm tenured. And I would say the same thing about my stay at Kent Law School. I thought I had some coherent thoughts to utter at this particular point, but I find that there's a lot of things I want to respond off of and add to what Steve says. So before I forget those and go into my spiel, shall we say, I'm amazed at how some of the issues that I now grapple with as a director of pro bono activities are similar to the issues that clinicians are still grappling with also. I have to grapple every day with what is the definition of pro bono, meaning what is the definition of the delivery of legal services. And there are some things that we do which I say are absolutely beneficial to the public, but which do not count in our grand scheme of external reporting to the American lawyer. I could spend all my time filling out surveys for the American Lawyer, for Vault, for NALP, for the Pro Bono Institute, and everyone has a different definition of pro bono. Everyone has a different definition of whose time counts. But for me, the most graphic problem in this area is if I am appointed to represent a youngster who has been charged with murder by virtue of accountability because he was the driver of the car or gave the weapon or shouted a gang slogan, everybody would say, that's classic pro bono. Everybody knows that counts, that's no problem. You represent that person. That's one person. Maybe if I'm lucky, I keep them out of prison. I would much prefer to go to a high school in a poor area and talk with 50 kids and say, let me tell you about the law of accountability. Don't get into the car, don't give the weapon, don't shout out a gang slogan. And if I keep 3 of those kids out of the criminal justice system, I've accomplished more. That does not count as the delivery of legal services under the definitions that we all use. So many of our concerns are the same. Now, I thought that I had left in some sense, I thought I had left clinical education behind when I left Kent Law School 9 years ago. There I was, 20 years at Kent Law School as a clinician. Dan, where's Dan now? There he is. He's the one who basically took my place or came shortly afterwards. It was a fee-generating clinic. I taught evidence and various lawyering skills classes. Even then, would work with Marc. I remember one of our biggest cases came when Marc said, I can't represent this doctor who's at Elgin Mental Health on discharge. Everyone thinks he should be discharged. We worked on that case at Kent Law School and brought it over to Mayor Brown with me. Fortunately, he was released, but the law has now changed as a result of that, making it more difficult. But I was in my middle 50s. I thought that quite frankly, Dan, I thought that at that point the clinical program was running out of some steam and creativity, and I was looking around to figure out what else I could do. But alas, nobody was looking for a 55-year-old Jewish male who was not law review at Harvard or Yale, and so, you know, the search for a deanship didn't get anywhere, and then suddenly I got a call from a partner at Mayor Brown who said, we would like to combine pro bono and training. How would you like to come over to the law firm? I didn't even know what Mayor Brown was at that point, didn't know where it was. I had teased my students for years about being seduced by the dark side of the force and that they did not have to go into a big firm. Of course, now they see me on the street and ask what happened, and my response is, well, if we're using movie analogies, they made me an offer I could not refuse. So the offer was, how would you like to come over to the law firm, bring your cases, do exactly what you were doing at the law school at more than double the pay? I wasn't a religious person, but I looked to the heavens at that point and said, thank you. I tried to quit that afternoon, but the dean reminded me it was the middle of the semester and I still had responsibilities. So I started at Mayor Brown on June 1, 1999. Interestingly enough, my initial title was Director of Pro Bono Activities and Clinical Legal Education. I mean, they clearly articulated, in fact, there was a partner who was also, had started out as a professor at U of C, Jim Holzhauer, who said, that's your title, that's what we want you to do. At that point, having come from a regional law school, with the background that I did, looking, because I knew no one there, I was trying to establish credibility, and if they had asked me to water the plants, I would have watered the plants, because I felt like a fish out of water. So what quickly happened was the development of Director of Litigation Training. So what is Mayor Brown now? Mayor Brown is 1,800 lawyers, 1,000 in the United States, 500 in Europe, 300 in Asia. It's an international law firm, which to me then means that my pro bono work has to be international in scope, even if we do not get that much involvement. The Parisians don't know what the word pro bono means. We've opened our first pro bono file out of the Parisian office, and I think it's going to go upwards from there. But the resources that these large international law firms have are astounding, and I see no reason why they should not be at the service of clinical legal education and legal education, that there should be partnerships and collaborations. I have an assistant director who works full-time out of our DC office, does only pro bono, not any training. There is a partner that I inherited when we joined with Rowan Moore in London. She does nothing but pro bono, works 3 days a week. I have someone in marketing who is assigned to do all of our pro bono publications, marketing, and things that have to be published. I have a full-time paralegal who works on the Seventh Circuit project full-time with me, a secretary, and then anyone I can find at the firm who's not doing anything at a particular time, I will find something for them to do. So the resources are incredible, and among the things we're able to do is a magazine called the Pro Bono Update, and Steve said, yeah, we have an article in the last issue teaching a clinic on the Supreme Court, which talks all about our partnership with Yale. We've done partnerships with Northwestern Law School. I myself teach a seminar every spring, or co-teach a seminar at Northwestern called Pro Bono Theory and Practice. In terms of the finances of it, I went to the dean and said, David, the firm wants to know how much you're going to pay me so they can figure that into your salary. And he said, come on, Mark, you're lucky that we don't make you pay us for the privilege of recruiting at the law school. So I don't think when you are dealing with large law firms, you have to worry about paying them the money, because one, probably half the lawyers at the large law firms would prefer to be teaching, but they had huge debts to pay, and so therefore they get used to the money, but they love teaching, so they'll always do that, all right? But all I want to talk about now is my job is the director of pro bono. That's part administrative. That's the part I like the least. I'm in charge of our financial contributions to public interest legal groups, which roughly is about $1 million a year at this point. And we have integrated the financial contributions into the operation of our pro bono program in the following way. I don't do, nor do I push, the traditional legal aid type approach. We don't do, for example, we do not do landlord-tenant because I think you could do those kinds of cases forever and it wouldn't give poor people affordable, decent housing. So instead, I have involved our corporate department and our real estate department in being National Pro Bono Counsel for a wonderful affordable housing group called the Corporation for Supportive Housing, which works with ex-offenders, reentry issues, and they put together developments where social workers are embedded. That seems to me to have more of an impact on housing and its availability than landlord-tenant cases do. But the people who do that kind of work are doing good work, decent work. It should be supported. So what we would say to them is, here's X amount of money. You can either hire a pro bono coordinator to chase pro bono volunteers, or you can hire a staff attorney who will probably do more cases and more efficiently, do it more efficiently. With respect to the litigation training, it is limited only to the interactive, learn by doing, what we now call NEDA-type programs. That's all I have the time to do, deposition training, evidentiary privileges, etc. The most fun part of my job is being a clinical law professor. It is working when Tara was at the law firm and we did a death penalty case, to work with her on developing memorandums of law and watching as she put on her first witness in a sentencing hearing. A month ago, we had a pro bono felony aggravated kidnapping case. I was able to sit there while three female associates, did the opening, the closing, strategized the entire case, working with me on it under my supervision, but they did all the work. I tried to stay out of the way, but I must admit, by the end of the case, the three of them went to the deputy sheriff and asked if I could be handcuffed to the chair next to the defendant so I wouldn't bother them anymore. But they got to do opening, closing, direct cross-examination, examination and strategizing, and learning how to put on a psychiatrist and a clinical psychologist, and learning how to cross-examine the state psychiatrist and psychologist. And I think it was a phenomenal experience. It's what I liked the most. What then leads me to question is, what does that mean? Have I been a clinical professor, and what does that actually mean? Does it simply mean, is it a function of my personality? Because I like working with younger, less experienced people? Have I learned skills by osmosis that I'm not even aware of? Or is there something there? Or is it simply the old-fashioned art of mentoring, which has fallen down in large law firms as they get larger and larger and larger?
All right. Well, it's certainly, for me, a very exciting and interesting time to talk about the future of clinical education, or to help sort of talk about. Can you hear me? Can folks hear me? All right. Can you hear me? All right. All right. And to talk about future models of clinical education. And it's exciting because of the increased recognition of the centrality of clinical programs to law school education, as evidenced in the Carnegie Report and also in the Best Practices Study Report that we referenced earlier this morning. And it's interesting because I think we are currently witnessing a marked tension in clinical education, and it's a tension between where we've come from and where we are going. So where did we come from? Clinical education was originally premised on the notion of providing individualized representation to under-resourced individuals whose legal needs might not have otherwise been met. And this notion of clinical education flowed directly from the legal services model, and this model established some of the basic tenets of clinical education, or perhaps what could be called the assumptions that underlay top-notch clinical education. That's individual representation of an under-resourced client in furtherance of a social justice mission. So where are we now? Clinical education has expanded greatly over the past decade or so to include other components and goals, and this expansion is only going to continue in the future. So some of this work includes community education, policy work related to systemic reform, legislative advocacy, and media advocacy. And also, clinics have expanded beyond the provision of traditional legal services to include other services. And some of these clinics, as Steve mentioned, do not represent individual clients, but they take on tasks such as writing white papers and reports for advocacy groups and governmental agencies. They write educational materials for the legal community. They push to develop model standards, whether it's at the federal level or in their local jurisdictions. They convene meetings of key stakeholders. They work on legislative and administrative issues. They train judges and legal services organizations, and they partner with groups that are striving for systemic change. So we now have clinics that fall outside the traditional legal services model and provide services that go beyond individual representation or do not even include individual representation. So we have mediation clinics, we have street law clinics, community organizing clinics, and even a juvenile clinic or two that do not provide individual representation. Then we also have some clinics that arguably don't have a social justice mission. So we have some IP clinics, we have some small business clinics, and we have some legislative clinics. I'm not saying none of these provide, I'm not saying all of these don't have a social justice mission, but I think some of them arguably do not. So these developments have led to some tension within our community about what constitutes clinical education. Some of this tension takes place within our own institutions, and some of these tensions are aired out in national conversations. I could think of at least one that I could talk about later on. So just to follow up on some of the questions that I think we should talk about, and some of these fall right directly on Steve's question. So what are the core elements, in your opinions, what are the core elements of clinical education? What makes a clinic a clinic? If we are not teaching traditional legal clinics, what pedagogical approaches should we take? Do we teach these students the same skills and values that we would in traditional clinics? Do you need clients for effective clinical education? And so these are all questions that we have to grapple with if we're going to define future models. The other question that Steve mentioned that I want to get back to is, should we have mandatory clinical education? Emily Buss talked about some of the hurdles she envisioned to mandatory clinical education. And I think that if we're going to argue for it, we need to sort of grapple with those hurdles. But so folks have talked about a lot of the benefits of clinical education. We've heard from Jonathan about empathy and responsibility and advocacy and fact investigation. We've heard about judgment and assumptions. I just want to throw two more out that are very much connected to this. But number one is students dealing with difference. Students working with clients and working in communities, folks who they've never encountered before in their life, the types of folks they've never encountered before in their lives, and folks going out into the communities. For instance, I work at the law school that's in the middle of Baltimore, and from my clinic, we go out to various communities, and even though my students are second and third year students, we're going to neighborhoods that they have never before thought of about visiting. These are the neighborhoods that even they watch on the wire, and even though they're located, they live a mile away from these neighborhoods. I mention the wire only because when I say Baltimore, that's the first question people ask me about, so that's why I threw that out there. And the other thing is teamwork. Law school is a very isolated experience. I reflect back on my law school education. I know that in my first year legal and research and writing course, we had to do this Hodes tour. We went around with a book, and we had to have a partner, and we went around to sort of see where various statutes were. But that's the only teamwork I remember other than when I was in clinic. So I think that clinical education is important to develop teamwork skills in our students as well. And if we do have mandatory clinical education, if not, that's an assumption, but let's assume we do have mandatory education, then it seems as though we have to have a broad definition of clinical education. So I'm going to ask some questions that Herschella and Craig wanted us to answer, but we figured the easier job is just to talk about it. But should clinics be one-semester clinics, or should they be full-year clinics? Do clinics need to have a social justice mission? So these are some questions that sort of seem to be tied to the whole question of mandatory clinical education. So the last thing I want to say is that we as a national clinical community have done a very good job of supporting our colleagues who have been confronted by their schools and certain community members for political reasons. But now that we're moving forward to this next phase of clinical education, the next 50 years, if you will, we also need to be prepared to support our colleagues whose role as clinical educators may be questioned because of disagreements over what clinical education really is. So those are some questions, some issues that we wanted to tackle.
Could I backing up or commenting off of what you say, I two things. One is about the issues that I deal with as pro bono director being the same. The issue of mandatory clinical education seems to me to be the same as the issue of mandatory pro bono, both in law school and in the practice of law, and who should do it and for what reason is it done. The large firms, especially New York, become obsessed with the American lawyers A-list, and the A-list means that you have at least 20 hours of pro bono per lawyer and the percentage that gets done through it. So there are some firms that have instituted mandatory pro bono, and I don't think for a good reason, but the question would be, okay, despite the bad reason, is something good being done? The second thing would be what you talk about with respect to teamwork and what I would call humility, is when you get the kids who come into the large elite firms, they need to learn some humility. There is no better way to see that humility when a prosecutor at a state felony court gives a really great closing argument and they're sitting there saying, oh my God, you know, we haven't done as good a job as they have. But every case that we do always enhances or talks about, or it's the notion of teamwork, because it is always a team, be it a partner, a mid-level, and a junior associate or a summer associate. So you're always enhancing what I would call those kinds of clinical values, learning to work together.
And let me just add a comment too. We've heard more than once today that not everybody can do everything. In my life, I've basically been a lawyer for individual clients, and that's how I see myself and how I experience the practice of law. I do appreciate that law school clinics are a scarce resource, and that it's really indulgent of us to represent one client at a time when there's huge community needs that we could be harnessing the resources of the university to address. I very much admire what Michael is doing with this reentry program. It's obvious that one of the huge major social problems we have today is people coming out of prison, not being able to get jobs. You can't work, what are you going to do? End up back in prison again. Reentry is a huge problem. If you did that one client at a time, you wouldn't accomplish very much. I think taking on legislative advocacy and removing obstacles to employment for people coming out of correctional institutions, extremely important work. It's not what I do. I like to have a relationship with a client. I like to work with a student where we're representing a client, whether it's a landlord-tenant case or a 1983 civil rights action, which I also like to do. Not all of us can do everything. And not all of us should try to do everything. I think similarly, most academic law school teachers can't do clinical work. They just can't. On my faculty, none of the academics have ever practiced law. I mean, we have a scholar in residence program in our clinic, so we invite members of the academic faculty to come in and spend a semester with us and choose the clinics that interest them and teach social policy stuff in those clinics. And so far, 4 members of the academic faculty with no practice background have done that, and they've become 4 major supporters of the clinical program. So there are ways to make connections with the academic faculty without expecting them to be teaching about the practice of law in their courses, because they don't know what it is. So I think what Marc said this morning was exactly right. All that we should expect from them is that they not attack us, not try to limit what we're doing. When we say we want to double the size of the clinical faculty, they should say yes. So I think there is an important ethical, moral question. If the law school is such a scarce resource, how can we justify representing individual clients? Shouldn't we be taking on broader? And I don't know the right answer to that. I really don't. Yeah. There's also the tension between providing service and the educational experience of students. Many clinics spend a lot of time doing simulations. Michael and I have engaged in print in a little argument about that, whether you can't learn the same things and learn them better by actually providing service to human beings rather than playing let's pretend, but that's a different conversation.
Yeah. I just kind of say a couple of things. Steve's point about the teaching of skills or clinic-related stuff in sort of the quote-unquote, well, the other curriculum, I don't know, doctrinal stand-up, whatever we want to call it. One of the things that's been interesting at my school is we've had issues relating to, let's just call them diversity-related issues amongst the student population. And one of the things we've pushed in response to that is for folks to bring diversity issues into their stand-up classes. And because you can look at just about any class in this quote-unquote doctrinal curriculum, and I'm not going to say all of them, but pretty much all of them, if you teach it in a certain way, you could tease out these issues that are involved in these cases. And we've tried to push that at our school, and you can imagine the pushback we received because of it. But I also think that clinical education, if you go to a law school where you're not going to get that in your stand-up courses, you're going to get that in the clinic as well. And you could bring that to me, that just strengthens these courses if you have students who could then bring those back. So that's another, it's not really clinic related, but it is in a way. So I just want to throw that out there as well.
I actually think that issues of cross-cultural lawyering are central to the work that we do.
Absolutely.
Well, Michael, I think I want to try to push you a little bit on something that as Emily first raised, and I think everyone on this panel raised, as we're thinking about the future of clinical legal education. There's been a trend over the years. Obviously, clinics have grown dramatically, and you know, and it's certainly easy to imagine or imaginable that within the next 10 years, at least in most resource law schools, that clinical legal education would, or should be made a part of every student's education, the whole mandatory clinic concept. If some of us got that wish, clinical education for everyone, I mean, how are we going to accomplish that? I'd like you to try to start teasing out, how would we accomplish it? What would we be doing, and what would we be doing differently if we were trying to serve every student?
Right. Well, let me just say that, you know, I think the biggest argument, well, a couple of arguments in support of mandatory education, and I think that the Carnegie Report, and we talked about it, obviously there's a disconnect between traditional legal education and the practice of law. And that bridge is supposed to be the bar exam, but that bar exam doesn't work at all. I mean, it's just, you know, so the reason for mandatory clinical education is to give students a grounding in the actual practice of law before they practice and whether or not they practice law or not. If you come to law school, you should be exposed to the practice of law. Whether or not you use it later on, that's on you. And when we look at other professional disciplines, they have that component in their education. So how would that be accomplished? I mean, that's a very difficult question to grapple with, but I would say that it has to start with being very, very broad. We may have to broaden our definition of clinical education. We would have to obviously expand the clinical offerings, and that gets back to the whole social justice mission. I don't know that you could argue for mandatory clinical education and then also say, but all these clinics have to have a social justice mission, because schools, if we want schools to buy into this, right, schools, we all have different agendas as well, so I don't know that a school's going to buy into that particular mission as well. They're going to say, look, you can't impose these clinics on us, but then all of them have to serve social justice. We all probably define social justice differently as well. So just because I say something's not social justice doesn't mean it's not, and the same thing goes with NS as well, although I think there's certain clinics that we could point to that, you know, many of us would say that's not about social justice. In terms of the cost that Emily talks about, I mean, obviously, that's a very, very huge issue. But again, if we have a broad definition of clinical education that would involve externships and things that schools are already doing to actually lessen the cost, then those are maybe some routes that we need to look at. And in terms of the argument that it could diminish the quality of the education, I mean, that's interesting. I had not really thought about that argument before, but I do know now that we have a curriculum, much of which, at least in the first year, depending on the school you go to, is prescribed, that does not have a connection to the actual sort of practice of law. And we need to do more to teach our students sort of the realities of law practice. And again, if they don't practice law, just to be exposed to something different from what you're used to. Now, how we do it, there's all different types of ways to do it, none of which are easy. But I mean, I think we have to sort of be entrepreneurial in how we define clinical education as a start.
Steve, let me go to you for a second, because you at least expressed some uncertainty or skepticism about whether you'd be in favor in the long term of mandatory clinics. I guess I'll let you define it. I'll let you define it. But what do you see, just as Emily raised, and not just money cost issues, but what do you see as some of the potential cost of making clinic mandatory?
Law schools are expensive places to run. I'm sure that Randall Picker gets a very nice salary. You know, I think you first decide what it is that a law school should be teaching and what students have a right to expect from their legal education, and then you figure out a way to pay for it. And if it means that there should be universal availability of clinics to every student, or if it even means mandatory, then law school should pay for it. There's lots of rich alumni who, I mean, that whole building you have there, which is the most beautiful clinic in the world, was paid for by your alumni. I mean, there's lots of money out there. I also think that we, I keep coming back to this, need to think more about how to involve the wealthy law firms in assisting us in providing clinical education experiences to our students. More and more law firms are hiring people like Marc. Schulte, Roth, and Zabel hired Danny Greenberg, who was head of New York Legal Aid Society.
George
there are lots
Kendall.
of law firms that are
right.
now hiring former clinicians or legal services lawyers as pro bono coordinators. And I think that working with law school clinics is a very effective way for those firms to get involved in this kind of work.
It's interesting you mentioned that, because in fact, I pulled out the original proposal that I had in my file, and I see that in March of 2002, Craig and I went to Mayor Brown and U of C to start what then would have been probably the first appellate clinic in the country, and the firm was in favor of it. In all honesty, the dean was not, and the dean's notion was, I want more out of Mayor Brown than just a clinic. And I think we really, it would have fit in with our existing Seventh Circuit project, which by now we've taken over, well, I think we're up to 110 cases from the Seventh Circuit. There is nothing like a first-year associate, again, Tara had that experience, appearing before Posner, Easterbrook, Diane Wood. That's a unique experience in your
I'd
life.
rather be tortured.
Well, Marc, we may be coming to you again, so.
Right, I know.
But
Be careful about that now.
you know, it's one of the things, and Michael, you raised this, but this can be addressed by anyone. Really, everyone's raised it to some extent. Yeah, and I'm going to bring everybody in. Social justice mission. I mean, certainly a part of this whole central part of the whole clinical legal education movement has been in and around social justice. It's a part of, in terms of Mandel, it's a part of our very mission. If you looked up what our mission is, you know, particularly if we're thinking about, or if there's a move then toward, again, addressing and serving more students, how does that complicate that? Are we able to retain, or what are we able to retain of that social justice mission? And Michael, as you said, one person's notion of social justice may be another person's heresy. I mean, there are right now, I mean, a number of NGOs out there who do everything from let's fight affirmative action, let's end public benefits for poor people, whichever side of the abortion issue, or anti-regulations in terms of the environment. Are these appropriate clinical projects as we think about the next 50 years?
That question goes to me.
That goes to anyone who wants to take it.
You think so? You know, I don't know. I mean, because that question is so personal. I mean, for me, I truly believe that clinics should have a social justice mission, based on my definition, honestly, of social justice, right? And I believe that clinics should take on broader roles in the community, so individual representation is an important component of it. But I really believe that law schools, we have the resources and we have in our communities to really engage the legal system at a very broad level. We have, I mean, for whatever reason, I mean, I'm in a state school in Maryland. We have two state schools. We have two law schools in Maryland. So we can convene meetings without chief judges and with our legislators right away. And we should use those tools to help the folks in our communities. That's part of my definition of social justice.
Those folks are poor people who are discriminated against.
Right, folks who, right, we're sort of we're both the first people and the last people they can rely on, right? But that leaves us with the other issues, and I believe, look, my opinion is there are going to be clinics with which I disagree with their missions. And again, that may fall outside my definition of social justice, but I do feel as though it's important to have those clinical programs as well.
But I think politically speaking, if we're seeking to expand the notion of who should be attracted to clinical education, you know, I guess some of us are born with liberal left analysis, and some seem to be born with a different kind of analysis, and I'm not quite sure I'm going to change their minds. I assume that those people who want to become transactional lawyers, and of course Mayor Brown has a huge number of transactional lawyers. My job is to try to find something of interest for them to do. The hook may be, okay, you're a first-year real estate associate, you're going to get to run your own deal. You're going to get to run your own loan closing deal. It could range anywhere from $250,000 up to $1 million, and when you gain this experience, you can go off then and build hotels and shopping centers and everything like that. Oh, and by the way, the loan closing deal is for an affordable housing unit for ex-offenders, AIDS patients, and everything like that. We're also doing microfinance work. So I think if you use that model to, shall we say, entice the more conservative law student by having entrepreneurial clinics, that's okay, because I think economic well-being is a
Plenty
right.
of clinics are doing that.
Yeah.
I mean, economic development and transactional clinics are everywhere.
Yeah,
And they're working for poor people.
And the partnership at Yale involved not only Covington and Burling and other law firms, but you also had Shore Bank involved with it, and they would come up and help with it, and that's given us more of an entree and a relationship with a client of ours. So we're always looking for partnership opportunities.
But this will be the last thing, and I want to open up to everyone. So I just want to push you a little bit on this, Mark. So Steve, as you said also, in terms of keeping it real, the reality is that the vast majority of the law students, at least that come out of University of Chicago, work for large firms like Mayer Brown, and upon their graduation will be working largely for corporations. So what about clinics that actually defend corporations? We're talking about preparing for students to do what they're going to do. They will be representing interest of tobacco, drug companies, et cetera, defending against employment discrimination. Is that appropriate for a clinic?
Quite frankly, I don't think it is appropriate, and I don't think the tobacco companies are going to come to the law school. For example,
sure they would. Oh, you bet they would.
For what? For representation or money?
If they could get the University of Chicago Clinic to defend them in these tobacco cases, you don't think they would come here? You bet they would. No, we shouldn't do that.
Yeah, I don't think so.
We should represent, poor people.
At Kent Law School, in the criminal clinic, Danny and I, although anyone who would walk in the door who could afford the fees, which weren't that much, but strangely enough, we never got big drug dealers, we never got organized crime figures, we didn't get a lot of political corruption. It was your traditional poor person practice, because I don't think those people are going to come to the law school and necessarily trust us.
Let's open this up to get folks involved. So are you trying to ask?
For what, though? For what did you?
Go ahead.
This is for Mark. This is for Mark, who I think has a unique insight into the economics mindset.
You want to know how you can get his firm?
Yeah.
Northwesterners, they're geniuses at getting money out of law firms. You get a call a week from an opportunity for you to fund something at Northwestern.
But anyway, my question is, do you think that law schools are doing an acceptable job of preparing students for the challenges that meet the large law firms? And if not, the question is, why are law schools getting away with that? How are they getting away with diverting most of their resources to research, to hiring faculty who don't have practice experience, that aren't incentivized really to learn about practice and teach about practice? And it seems to me that they're getting away with it because one of the reasons is there's absolutely no pressure from the big firms to change legal education. They basically seem to wash their hands of it and don't really care what happens at law school. They want really bright people. They think they can, with a baseline of first-year legal reasoning, of course. So I guess my question to you is my construction of the situation accurate? And if so, is there anything that can be done with it?
In many ways, I think, unfortunately, the large law firms are lemming-like. One raises the salary for associates in theirs, and immediately everyone jumps over the cliff without thinking. I'm not certain that there's a great deal of creativity in what they do in recruiting. I'm sure that your students it's Monday, I'm interviewing a white male. Am I at Sidley? Am I at Kirkland? I'm at Mayor? I forget. I can't. They all look the same. They all ask me the same kinds of questions. So I'm not sure. I think the law firms are starting to become better at those kinds of things. I think they have a long way to go. I do note that, at least from my perspective, Larry Kramer was at the dean at Stanford has been at our law school a number of times, and we have had a reputation for being one of the few law firms that actually hires law school faculty on an adjunct basis. I've become friendly with a man who I disagree with completely politically, but he is part of our law firm at this point. That's Eugene Volokh in the Volokh Conspiracy, and he's done several pro bono matters through our Seventh Circuit project. And I have a secret to tell you. His first draft of his brief for the Seventh Circuit looked like a blog entry because Gene had never practiced the law before. So I think you're right. The law firms don't make demands on like that. I think they possibly think, well, in the first year, all the associates do is what they do in law school anyhow, which is a lot of research and writing and document review. And okay, Mark, yeah, you can, they'll do pro bono with you, and then they'll learn stuff. So we're slowly incorporating that better. But I think that the law firms, as they get larger, and even, we're like multinational corporations. Instead of delivering steel, we deliver ideas. And so I think that they have a responsibility to push back on the law schools.
Yeah, I have a comment first, and then a tough question for Mike. The comment is,
He's the president of Leah.
huh?
He's the president of Leah.
That's what I'm asking about. I don't think that talking about mandatory clinic is the right way to phrase it. We fought for mandatory ethics, and that's been iffy at best. I mean, some places it's just talk about those two faculty member, somebody in the students thinks uninteresting and unimportant. But right, so I was thinking what we ought to be doing is elevating ourselves into the core curriculum. And the core curriculum is what is required of most schools, and is taught by full-time faculty, and or at least we ought to be in the core electives. You know how a lot of the announcements or in the catalog will list suggested courses that you take if you're going to go to different fields. And these ought to be seen as not just these little add-ons, extra value or whatever, added value as part of the core. So I'd like to see the thinking about changing the dialogue, changing the vocabulary. Now, the direct question for Michael is, now you're the Clever president, or the CLEA president, Community Legal Education Association, in the next 9 months. I feel like I'm on those debates.
Yeah.
What are you going to do to initiate and procure the adoption of a new accreditation requirement that the clinical education become part of the core curriculum at a time when everybody gets a chance to take it?
I'm sorry, the last part of what you said
Or
dropped off.
universal availability.
Universal availability. Well, okay. That's not, Gary and I speak about once a week about this stuff, so that wasn't really on the agenda, but the question is, should it? Well, no, we actually submitted a letter and Gary signed on the letter too, last year, actually about 6 or 7 months ago, to the accreditation committee that was looking at all the standards for law schools, and we argued in the letter that they should think about mandatory clinical education. It was based on a question that was asked at the hearing of Paula Williams by Dick Morgan, who was the chair of the Standards Review Committee, that basically provided an opening for us to argue that. And so we did. It obviously went nowhere. And I don't know that now is the time. I mean, given all the vocabulary issues and all the tensions that I think are coming up right now, I don't know now is the time to really push the argument without us really thinking through what it's going to mean for the curriculum and sort of, I would think we would have to come with a pretty strong sort of ironclad argument to present it in the way that you're talking about. And I do think, though, that some of the other issues we're talking about, we could chip away at it. And I'm not saying we're going to come to that point, but some of the other issues that I think we're trying to address might chip away at that somewhere down the road. That's all. So yeah, thanks for that tough
There's
question.
a
Yeah.
question in the back.
Being at the University of Chicago, I went here for undergrad and I'm about to finish up the law school. So 7 years of my life have been based around economic thought. So I have a supply-demand question. Mr. Kadish,
We're going to start by assuming the world is flat, right?
say again.
We're going to start by assuming the world is flat.
Mr. Kadish touched on the now vault and law rankings and having that in part based on the supply and the requests or demands of law students who you're interviewing wanting pro bono experience and wanting to have that be something that is part of their continuing legal education during their time at the firm. Using a similar notion then, do you think that the demand for increased clinical practice at law schools will be or should be based on would-be law students wanting those practices as well? I'm just, and if that's true, how do you synthesize that with things like Randy's statement at lunch that she had no idea what she wanted to do when she came to law school?
Well, it actually was directed to the clinicians because it was a question
No,
of
I
what
heard
to
it.
do
She
with
said-
law
she
schools.
said you.
No, she just mentioned my name as a, the funny thing is that there is no empirical verification that I'm aware of how many students come to the firm and demand pro bono work, or is there a survey of even students saying, I chose this firm because of their pro bono program? So likewise, I'm not aware of any survey, but I wouldn't be the one who can examine that at this point, of students pushing the law schools for additional clinical education opportunities. Sometimes I think I have, I guess the point I was, sometimes I think I have the greatest job in the world and I feel like I'm the moral compass of the law firm, and some days I feel like I'm an old rabbi or priest lecturing into the wind and no one is listening. So, but all of life, involves those kinds of choices. I think that legal education is incredibly complex these days, and I think being part of a large law firm and what they stand for, what they do, involves compromises, but also involves grayness. Part of it good, part of it bad, but that would be a whole other conference, where you go from things like ethical conflicts, business conflicts, and the constraints on your time, and where there is. We had no problem with Guantanamo. Surprised me, all the stuff came out about the federal person saying all these law firms, the corporations should fire them because of their work on Guantanamo Bay. And I brought the statement.
He ended up losing his job.
Yes, he ended up losing his job, and I brought the statement. It came over the wires. I started getting it right away, and I said, "Oh my God!" And I ran around the corner to the chair of the firm, who conservative Republican, and he looked at the list and he said, "At least we're in good company." And then threw it down and said, said, "Oh, he's an don't worry about him." And then, much to my surprise, because I think I fell into some of my old days in the 60s of black and white, some corporations would privately write us and say, "Congratulations on that work, we support you, and as a matter of fact, we're going to give you more business because of that." Well, I was totally flabbergasted by something like that. So I think that there are these contradictions that exist within legal education and within the practice of law. It becomes our job to try to take advantage of them in a good way.
I'm here with my question. What do you think should be the profile of clinical faculty in the future? In thinking about how to staff clinics when we go forward. Obviously the law schools have model. We have model, UC has a model for its tenure track.
So you remember when we started?
Yeah.
Either you were in legal aid or you were a public defender.
Right. But but should the profile be different? Should, I'm thinking about that because I'm,
It's a mirror of the non-clinical faculty. As we become more entrepreneurial in our clinical programs and start doing complicated transactional work, other kinds of stuff that we never did at the beginning, then you really need to have people teaching that who know what they're doing. To run a transactional clinic, for a clinician to run a transactional clinic who's never done a deal, seems to me really foolish. So it's one thing to harness the assistance of law firms, but it's another thing to say we really ought to be looking generally. I know that elite law schools like yours do not practice slotism. You look for the best people around and then they teach whatever they want. But actually, I think we need to practice slotism. We need to say, what kind of clinics do we want to have? And let's go find people who can teach that kind of clinic.
But, no, go ahead. No, go ahead.
If one of the things we're trying to say is, what should the future look like? And we're talking about harnessing the energy of, or the resources of the large law firms.
Actually, Mark, I wasn't asking that.
But I think...
He wants to talk about that.
No, but what my thought, Tom, would be when you talk about the quality of clinicians or what they should look like, I see no reason why there should not be more collaboration on a day-to-day teaching level. And I think sometimes the problem of the law schools is that they look to the firms solely for money and not for assistance in teaching. And I think I don't think they should be the core clinical faculty, but I think they should be adjuncts and in partnership and collaboration. So I think that's one way to look in the future.
And that they should finance the litigation.
Yeah, no, right.
Michael, go
No,
ahead.
it's a thorny question. And I don't know, I'm probably gonna go a little bit broader with it, but in the work that I do, for instance, getting back to the whole public defender legal services background, I have no community economic development experience, nor will I ever. That's just something I can't even touch. But the work that I do could benefit from a person who has some community economic development background to help create jobs, to help. I'm working with some people now who are going to build some houses, and we can get some people hired to build houses, but they have this sort of conception of how to sort of develop a certain part of Baltimore City. So you definitely need people with, I think, more diverse experiences that probably traditionally we had back in when Steve was putting bricks up at Yale Law School somewhere. I think that one of the interesting tensions that could possibly happen, I think maybe it's happened, this is sort of anecdotal, is, one of our big pushes is to make clinicians sort of an equal member of the faculty. And what does that mean? Well, in some schools that means that you have to do everything that the other faculty member has to do with regard to scholarship and things of that nature. So there's a tension between scholarship and the work that you do, but then you have law schools, including my own, that now, because there's a unitary track in my school, but when I was hired 6 years ago, they didn't really care if I had written anything or not. Whereas now, because there's this whole push to climb the ranks and everything like that, everyone to be an entry-level person in my school, you have to have basically one article, even on the clinical slot. So if you don't have one article, they're really not looking at you. And I think that's problematic. So that's a problem that I think we're going to have to think about as well. It's sort of sort of the downside, if you will, to sort of the whole status issue that we're all fighting for. The other thing is just in terms of the face of clinical education in the future. And I've said this a couple of times, but we just need much more diversity within clinical professions. We need more racial and ethnic diversity. All of us here, many of us here, we go to this conference every May. This year it's going to be in Tucson, Arizona. It's the biggest conference that the AALS puts on, but you could, if you wanted to, you could count the people of color on maybe if you had 4 hands put together. And so I think that that's one of the big things that we all have to advocate for as well, is to the extent, and I think for my school, it plays a big issue in the communities that we work with. It plays a big role in sort of faculty voice and all these issues as well. So, that's all part of it for me as well, in terms of what the future of clinical education should be about.
Mark's been patient.
So, I like that you started with a 50-year-old memory of the law school, but it seems to me it's useful to look back 50 years, because I don't think we're looking forward 50 years.
something different, not because you have no lawyers in your firm are creative about that, but because you're being forced by the market clients.
I think clients have much more power these days. Even, I mean, if I go to the firm and say, we should give $50,000 to the National Immigration Justice Center because it's the right thing to do, the response is, well, that's your job, Mark. We expect you to say that. That's very nice. Keep it up. On the other hand, if AT&T comes to us and says, we would like you to buy tables at a dinner, sometimes it's, they only want $10,000. No, we should give them $20,000. Maybe we should give them more. So clients do drive what the law firms do, but I don't think...
In terms of what the lawyers are capable of doing, not your pro bono work, not when you give money to them, not when you suck up to them, but whether by buying tables, but whether or not the clients are going to drive you to be hiring lawyers who are able to do different or more efficient things.
I don't think they've gotten that far yet.
No. Mark,
50 years.
every law firm partner that I talk to says, we don't want you training people, we want to train them. So it's great that you in the clinic are doing landlord-tenant cases and mental health cases and all the things that you do, but when it comes to the work we do, we want to socialize and train the people. We don't want you to do it. Which is why I keep saying the law firm should come into the law school and help us do what we want to do, rather than us trying to prepare people for them, because they don't want us to prepare people.
No,
They don't prefer people who have had clinical experience.
You're not responding to my question.
That's what I thought your question was.
The practice now, talking about what 50 years from now is, that is, the problem is, so the reality of the law practice now, the law firm can say that and get away with it. In the sense that if they're training their lawyers, they're spending client money. Okay? So law firms have to make money. They're money-making enterprises. And every partner has to take home some money, every associate. So I'm asking us to not, if you think about education, it's often quite frustrating to think about the changes that occurred in the last 5 years. If you think about the changes that occurred in the last 50 years, it's very heartening. I've been here for 30 of those 50 years, and it's night and day. So I'm asking you to think a little further into the future. And I agree with you about your description of the current reality. I'm talking about what the future is like.
The future for big law firms is to make lots of money and to represent people who can afford to pay them. And I don't see why we should help them do that.
And I also...
They ask us to do something different.
They're going to...
I think the most that... I think what is...
I'm glad I'm going to be out of here if that's going to happen.
I think what's going to happen in the future is that the globalization is permanent, and I think that parts of legal education will be transferred overseas because the practice of law will be transferred overseas. So I see that there's the possibility that American law firms will establish satellite schools in India teaching Indian lawyers how to do American discovery and electronic discovery because it's going to be cheaper for their lawyers to do it than our lawyers to do it. And I think that's the only thing that I see definitely happening 50 years into the future, because you're not going to be able to turn back that kind of tide of time. And it's clear that it is going to be, as the law firms become more international, the global economy, the world is flat, et cetera, et cetera.
Yeah.
Good discussion. I'm Ann Jordan. I work at William & Childer Law School in St. Paul, which is a non-elite law school. We have a unified tenure track, and I would suggest that the future, one possibility of the future is that we break down this dichotomy of clinic skills on one pole and doctrinal classroom on the other pole. And today, though it's been wonderful to think about these issues, but I'm surprised at the extent to which our rhetoric reinforces that polarization. And I would like us to, as we think about the next 50 years, at least as a proponent of clinical methods, say that not talking as if they were polar opposites is one thing that we need to also do. I have the privilege of working in a place where we're grappling with this so that I teach in the classroom professional responsibility, civil procedure, things over the years. I teach a large simulation-based trial advocacy course. We no longer call it trial advocacy. I always teach at least 50% of the time in the clinic. Michael, you're right. Everyone needs to write as well. I've come to see that in my own case, as I'm glad I was pressured to write. It's a form of communication. If we don't have to write narrow things, if we're talking about communication, sometimes now my beginners, I say, you've got so much to say, how are you going to say it? So how do we talk about the future of legal education? I would suggest we can't talk about as doctrine and skills, as goals. And let me give you an example. My first year contracts teachers, one of them is at my school. One of them is doing a year-long simulation using a payday loan situation based on real stuff she's learned about from the clinic, to have her students do an offer acceptance. It's a contract of adhesion. One of their things they have to do is go out into the community, is try and get a payday loan, or to go to a loan, a check cashing place, or a place to get a payday loan. And it's this wonderful simulation. They're learning contract doctrine, but they're also learning about the reality for poor people, how contract operates. It's clinical methods, though I don't think we can even own it as clinic. And it's a wonderful teaching experience. Similarly, our clinicians, we don't do any simulation because we have some required simulation courses, staging it. But if the whole curriculum gets permeated with people doing different methods, yes, we're not all competent to do all of it. But any contracts professor can do a year-long kind of simulation and get out into the world and figure out some exercises for students. And you could do that at any doctrinal course, and you could do it for any clinical course and substance. Just one other comment while I have the mic. The idea of I would suggest that non-client clinics, we have to watch out. I have 32 years experience as a lawyer, been a clinician since '84. Just like we're exhorting people to have more context in their legal education, I think clinics should be careful to have real connections with clients as we go forth to serve the public interest. But that's a whole other discussion. So your community groups who you're working on with the bank, they're critically important, and a lawyer-client relationship, I think, can ground you in a way that saying we only represent our great ideas and aren't we smart in the academy, that's a separate topic.
And can I ask one question back to you, going to your first point, and it's actually great that Randy came back into the room. Perfect time, Randy. How do you incorporate some of those clinical methods in a large classroom, in a classroom where you have 60 students or more even?
Well, I think that Professor Picker does some if he's having his students argue each side of a Supreme Court. Here's a 12b6 motion, argue each side in front of the class, and you take 20 minutes of class. My colleague with the contracts class that I discussed has 70 to 80 students in a section. We do some small group work. It's been years at my institution, William Mitchell, we bring in the cooperative learning specialists. We talk about teaching a lot with each other, and the critical thing is not everyone comes. 60% of the faculty comes, and that 60% keeps kind of changing. The clinic and skills people are pretty constant, but the doctrinal folks, and here I'm using the rhetoric I'm trying to move beyond, come to, and they find that it works, that engaged students are better than disengaged students, that different learning styles are reached, that they have better outcomes in their own experience with more teaching methods. There's lots written, Craig. We can talk.
And I think I'm going to respond to you as an old fuddy-duddy and say I don't agree with what you just said. Okay.
institutions are so different.
Yeah, it's true that my students in the clinic look at a piece of paper and don't realize it's a contract. But that's so what? Whenever that happens, I remember Malcolm Sharp teaching me contracts in my first year here in 1960 and telling us all that it was magic. Offer, acceptance, it's all magic. You know, so I said, of course you don't recognize that as a contract, because there isn't such a thing as a contract. But what we did learn is some very fundamental kind of legal ideas, which is what's the public interest in interfering in private arrangements? Why should there be a law of contracts? Why do we care about that? And that's what he taught us. And I came out of that course with a very kind of feeling, and I still feel to this day that it was the most important course I took in law school, because it was the real introduction. Back to Mark. What should we be doing to get ready for the law firms of the future? If the law firms of the future are doing antitrust, I think they want our students to know exactly what Randy Picker is teaching them. To know the economics, to know the case law, to know the doctrine, to understand how you analyze one of those cases. They'll teach them how to draft the complaint. I don't think that teaching complaint drafting is the important part of what we do, which is why I don't really want to be concerned with what the law firms are going to want from us in the future. I want to keep our focus on social justice stuff that maybe they're not doing.
Michelle.
Michelle. So just in thinking about clinical education 50 years from now, my two ways I see the world going in our generation is the increasing use of technology and globalization. I'm actually an international student who's studying in the U.S., and my family lives in both Nigeria and Australia, and when I tell them I was practicing going to the U.S., they always just assume I can help them, in Nigeria or Australia, and I think the clinic is one of the ways in which concepts that people would understand, like poor people needing to eat, or government interference to different things, can be applied internationally versus the 1286 notion that's unique to the U.S. law. So I was wondering how all three of you would see technology also being incorporated into clinical education, as well as globalization, or I don't know whether it's trips abroad or having students who are welcome to the U.S. and the partnership that way.
The technology component, but both of them are very, very important. Technology is obviously very central to law practice, and we need to train our students, if we can, on sort of the latest developments in technology, whether that's filing electronic briefs or knowing sort of the limits of putting stuff out on email. I mean, all these things now have e-discovery, all that stuff like that. And so a lot of schools are trying to stay abreast of it. My law school is certainly trying to do its part as well. I'm a little bit behind. I need to catch up. I'm not going to lie to you, but certainly that's a big part of what we do at my law school as well. So that's obviously critically important. In terms of the internationalization or the globalization of clinical law school education, certainly Tom Garrity could speak to it, I think, certainly more than, I can't speak for everybody in the room, but certainly more than I can in terms of the importance of sort of reaching beyond your communities and going abroad and bringing some of the principles you're teaching your students there to either bring them abroad or learn those principles to bring them here. I mean, obviously, that's just a very, very important component of legal education. I mean, again, if clinical education, getting back to Ann's point, is just part and parcel with just legal education and not separating the two, I mean, to the extent we all are affected by globalization, certainly our students need to be informed, better informed, if you will, of what's going on around the world.
And actually, on Tuesday night, I'm going to be in New York at the New York City Bar Association on a panel put together by the Committee on International Human Rights and the Pro Bono Committee on collaboration between law firms and international human rights clinics at law schools. So I think it is starting to develop at this point. At Mayor Brown, we will cooperate and have cooperated with Northwestern in their international trips where where students go abroad every spring semester. We've had one associate go to Tanzania, one associate go to Vietnam, and one associate go to Chile, and they've all written articles either in law journals about the experience or even for our magazine called the Pro Bono Update. The younger generation is mesmerized by international human rights. If I say to somebody, oh, we can do this project on the South Side versus there's this project in Nigeria, a ton of people are going to sign up for the Nigerian one. on one hand, I understand it because it's so much more, you know, black and white in terms of people being much, much poorer abroad than here. But I get a little nervous about whether or not are we suddenly forgetting that there's no poverty in the United States and we're looking overseas. What about people here? So I get nervous about it, but it's clear that people are fascinated by that notion of international human rights work, be it in Africa, India, whatever.
Yeah, I mean, a lot of schools now have exchange programs, even clinical exchange programs, where students are coming here. We're sending students abroad as well. But I agree with that concern. But also, there's some synergies, obviously, between what's going on here and what's going on in certain places abroad as well. So,
we've got to stop. Thank you, guys. Thank you.